Justice Mokgoro passed away on the 9th of May 2024. After her death, it was discovered that she had two wills dated 2014 and 2021. The two wills were similar except for one difference. Under the 2014 will, Justice Mokgoro gave 100% share in a property situated in Kimberly to her partner, lifetime partner, and as well as a vehicle, a Jeep Wrangler, to him, when she gave the rest of her assets to her children and a grandchild. And under the 2021 will, she had given her lifetime partner only the Jeep Wrangler, which is a vehicle, and gave her 100% share in the property to her children in equal shares, meaning that the children each got 25% of her share in the property. Now, after that, the estate was reported to the Master of the High Court in Kimberly. And the Master then accepted the 2014 will because the 2014 will had met the requirements for a basic will. The 2021 will, unfortunately, was not signed as per the requirements of the Wills Act, Section 2 of the Wills Act. So the Master could not accept it, resulting in the children and the executor of his estate having to go to the High Court in Kimberly to ask the court to order the Master of the High Court to accept the 2021 will as the last will that she had made. So they went to court, and the Master did not contest. The only person that contested the application was Justice Mokgoro's lifetime partner. He wanted only the 2014 will to be accepted. At stake in this matter was the shares, the 100% shares, share in a property situated at a golf estate in Kimberly. Okay, remember, in the first will, she had given 100% share to her life partner, and in the 2021, she had given that share to her children in equal shares. Okay, so now when the matter got to court, the court considered it, and it had to make a determination. Fortunately for her children, the court found that although the will was not signed in accordance with the requirements of the Wills Act, that it still can be passed as her last wishes. Okay, so it ordered the Master of the High Court to accept the will as her last will and testament. So, looking at the case itself, I was able to see that there is quite a lot to learn from the whole case. And this is what I will be sharing with you also. The first thing to learn is the importance of making sure that your will meets the requirements of the Wills Act, particularly Section 2(1) of the Wills Act. We'll also be looking at what are the consequences if a will does not meet the requirements of the Act. Then what happens? Okay, what is it that the court looks at? If you have to go to court, what is it that the court looks at in order to be able to say that Even though this will does not meet the requirements of the Wills Act, it can be accepted as the last will and testament of the deceased. Okay. We will also be looking at things to consider when drafting a will. There are certain things that I saw in the will that might be a bit of a challenge. So we're going to look at that, and also the cost of not meeting the requirements of a valid will. If you want to know more, to get the lessons, you can subscribe to the Kineilwe Mabapa YouTube channel. You could also follow me on Facebook and TikTok, because that is where I will be posting the videos, so that I will be able to share the lessons with you.